ಗೋಪಾಲ್ ಕೃಷ್ಣ, ನಿಮ್ ಮ್ಯಾಟರ್ ರೆಡಿ ಇದೀರಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 21.
ರೆಡಿ ಇಲ್ಲ. ಹಲೋ ನಾಗಣ್ಣ, ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ನಿಂದು?
ನಮ್ದು ನಡೆದ್ರೆ ಒಂದು ಹಾಫ್ ಅನ್ ಅವರ್
ನಡೀತಾ?
ಗೊತ್ತಿಲ್ಲ, ನಾವು ರೆಡಿ.
ಓಕೆ.
ಇನ್ನು ಕೋರ್ಟ್ ಶುರುವಾಗಿಲ್ರಿ ಮಿಸ್ಟರ್ ನಾಗರಾಜ್?
ಇವಲ್ಲ ಸರ್,
ಹಾ,
ಇವಲ್ಲ ಸರ್, ಇನ್ನೂ ಆಗಿಲ್ಲ.
ಯಾವಾಗ ಬರ್ತಾರಂತೆ?
ಕೇಳಿಸ್ತಾ ಇದೆ ತಾನೆ? ಅಲ್ಲ, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ನನ್ನ ವಾಯ್ಸು?
ಹಾ, ಕೇಳಿಸ್ತಾ ಇದೆ.
ಹಾ, ಸರಿ ಸರಿ ಸರಿ. ಗೊತ್ತಿಲ್ಲ ಸರ್ ಯಾವಾಗ ಬರ್ತಾರಂತದ್ದು.
ಇಲ್ಲ, ಇವರು ಡಿಕ್ಲೇರ್ ಮಾಡಿಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿಲ್ಲ ಇನ್ನು.
ಸೈನ್ ಗೀನ್ ಮಾಡೋದು ಕುತ್ಕೊಂಡಿರ್ತಾರೆ. ಸೈನ್ ಗೀನ್ ಮಾಡೋವೆಲ್ಲ ಇರ್ತಾವಲ್ಲ ಸರ್. ಇಲ್ಲ ಅಂದ್ರೆ ಯಾರಾದ್ರೂ ಹೊರಡೋ ಟೈಮ್ನಾಗ ಯಾರಾದ್ರೂ ಬಂದ್ಬಿಡ್ತಾರೆ ಇವರು.
ಸರಿ ಸರಿ ಆಯ್ತು.
With my lord's permission, on submission, my lord's a miscellaneous second appeal. Lord's trial court has remanded, the first appellate court has remanded the matter back to trial court on a rejection of plaint application. My lord, the trial court matter is listed on 17th March. As I request for 14th March for admission, my lords, an IA for stay has been filed in this matter. Greatly obliged.
And deposit by the insurance company has to be withdrawn for withdrawing of the amount.
Miscellaneous second appeal, madam. The similar matter also remanded before the trial. This matter also finally.
Monday.
In case of death, my lord, insurance company also charging the liability. Ground, my lord, the relationship between the claimants and the deceased was not approved. I have also filed a class objection from urgency, my lord, in the year 2021 matter.
Then what about 14-13 matters? We'll see, there is no urgency like that. Yes, for the list.
Page wise attainment, page one, list one, page one.
Actual matter is posted tomorrow.
Yes, post that also along with that.
1:30.
Yes, please.
Page wise adjournment, list one, page one.
1 minute, yes.
Serial number 3, my lord. Gagowda is unwell, may be taken up either on Friday or Monday, my lord.
Monday,
Please.
the request of learn counsel for the appellant.
Five, I have transition copy in the counter now.
Hmm,
Transition copy I have filed in the counter now.
your file,
Yes, madam.
then counsel submits that already the translated copy is
Serial number 5,
filed. Yes,
please, madam.
Serial number 7, madam. Process has to be paid. Please grant 1 week time.
Page two, serial number 4
so
to
in all
7.
this matters, sir, no, everything is for that only, just wait for a minute. Yes, next,
Page number 3.
don't call orders matters,
Okay.
interlocutory.
Hearing on interlocutory justification, page number 6. 10 to 12. Page 7. 13 to 17.
Serial number 16, madam.
Serial number?
Serial number
In
16.
admission first matter.
Minutes, I have not filed my wakalat yet, minutes. The copy is served on me today. Lordship could call it after 10 days, minutes. I'll be able to file and assist the court.
Even if after we hear this matter also, we'll give you the same time after that. To file the wakalat. The
matter is-
2013
the
matter.
appeal-
In your, finally a week's time is granted. The
Right.
request of learned counsel for the respondent.
Page number 8, serial number 18 to 20. Page 9, 21, 22. List number 2.
Lordship, serial number 21, my lord. I'm just misplaced the file. I'm not able to trace it today. Kindly week's time may be granted.
What is that?
21.
21 mile.
Uh,
File is misplaced. I'm not able to trace today. Please, a week's time may be granted.
the request, inform the other side,
I will inform my.
the request of the appellant, finally a week's time. Next.
Obliged.
List number 2, page 1, serial number 1, page 2, serial number 2 to 4, page 3, 5 to 7, page
My
4.
lord, appearing for the serial number line in the list 2, my lord, appearing for the petitioner, the advocate is met with an accident. Kindly raise
To
that.
petition advocate met with an accident. We submitted to the petition advocate met with an accident. This is matter when? When do you want?
Anytime with the local.
2 weeks?
That's okay.
Yeah.
Page number 4, serial number 12 to 16, list number 3, page 1, serial number 1 and 2.
Serial number 2, my lord. Serial number 2, my lord.
Yes.
A week, I am not feeling well, my lord. A week's time may be granted.
This is matter after 3 weeks. The request
Please.
will uncount for the appellant.
Page number,
Please
Page
don't
number-
ask adjournments in this 2013 matters at least.
page
not
number 2, serial number 3 to 8.
Lord, serial number 7. We are appearing for the appellant in this case. One of the counsel who was earlier appearing, he went a surgery in the last Saturday. Kindly, adjourn for 4 weeks.
Yes, 7. At the request of non-counsel for the appellant, 2 weeks time.
Page number 3, serial number 9 to 10, 9 and 10.
Serial number 10, my lord. 10.1, I have filed wakalat. 10, I have to file wakalat, my lord. Copy is not served on me. I will file
Then in
wakalat
that
in
case, then in that case, the matter is called and the advocate is before this court, we will ask him to serve a copy.
Yes, my lord.
And the
In the
matter
meanwhile,
is-
a week's time may be granted, I'll file wakalat, my lord.
No, you have to serve papers on you. For that, he has to come to the court. Yes, next.
Page number 4, serial number 11, 12.
Lord, serial number 12, my lord, some personal inconvenience, my lord, appellants with the liability issue, my lord. Lordship kindly, because I informed to other side.
2014 matter.
I'm agree, my lord, because the liability issue, my lord, because the act policy matter was pending in the Supreme Court matter, since the act policy referred to larger bench. This is the same policy
What is the present legal position? We will follow that.
today, some personal inconvenience, my lord.
Pending matters, we are not concerned. Whatever is the order of the Supreme Court, from that day we'll follow. What is the law that is ruling the field now, that we have to release these matters on next Thursday. If not Thursday, Wednesday.
19.
Yes.
My lord, serial number 10, my lord, I will go to his office and collect the papers, my lord. And I will send my colleague to take papers.
Serial number 10.
Yes. A week's time may be granted.
Mr. Taylor takes notice, already his name is there. He submits that he requires a week's time to file the wakalat, and also papers are not served. This is matter after a week. Yes.
Page number 5, serial number 13 to 18.
Serial number 15.
Serial.
I am
Okay.
okay. It may be taken up on 17. Senior is not there, even I don't have, senior is also not there, I don't have the papers also. Because I retired from this case and
Probably these matters are in list from when?
on 17th, kindly, on 17th, my lord, on Monday.
I am appear for appealant.
Why should the matters be listed? Casually, why should you ask for the time? That too in 2014 matters.
Actually, we have come now, my
Huh?
we have come now, we have filed the wakalat now, because.
It's
before
not
the
about
other
you, it is about your client.
side, that I've not got the documents also. I have informed the other side also.
I am appear for appealant.
People are not interested to pursue the matter, what to do? We'll adjourn it, on it. Next year we'll list this matter. This is matter after 2 weeks. No, every
Serial.
day, in spite of me requesting all the advocates, all 13, 14 matters, all matters are adjourned.
Your Lordship, serial number 18.
Serial number 16, my lord. Serial number 16, my lord.
3 weeks
Not-
time may be granted to file a translated copies, Your Lordship. Government is a party here.
What do you want?
I have to file a translation copy. 18, serial. With 3 weeks time may be
Because
granted.
when is that order?
It's order on 4/6/24. 24.
And now in 25, you require time again. It's an MFA of 2015. And right from 4/6/2024, the translated copy of the copies of the documents which are not in English language. What is this appeal about?
It's an MEC case, Your Lordship, in the
In MBC case, why you have to look at all the documents? You know Kannada, you will read Kannada, I will understand.
please, Your Lordship.
No, don't adjourn this matter. Yes, next.
A week's time may be take instructions, Your Lordship.
Instructions. Patch of matters. 4 matters are there.
Yeah, yes, Your Lordship.
Serial.
Very casual it has become, seeking adjournments. This is matter after 3 weeks.
Serial number 16, my lord. Not
Yes.
feeling well. Serial number 16, not feeling well.
Next week.
Serial number 14. I
Please.
represent minutes, respond number 1 to 3. He is unwell, minutes, Your Lordship could have it minutes any other day.
You're representing whom?
Respond number 1 to 3 minutes. Serial number 14, Prakasham Patel.
Submitted the council respondent is unwell. This is matter next week. From next week, will not entertain any of the adjournments in final hearing matters. Don't call final hearing from next week. That has to be argued. If they're not arguing, I'll look at the papers and pass orders on the merits of it. Yes.
Number 6, serial number 19, 7, 2021.
Yes, call the list.
List number 1. Altered matter, serial number 1. Gautam Raghunath, sub petitioner.
I've spoken to my
Second
learned friend
Telecast
representing the I'm happy for a petition. Spoken to my learned friend representing the respondent.
My lord, serial number 19 in the third list, my lord.
Yes.
Kindly, my lord, after 10 days.
Why?
My lord, because some additional documents have to be produced. And they said that they will send this week, my lord.
1415 appeal, why is additional documents in 2025? Why should the court entertain
My
that?
lord, because already we have settled, my lord, under personal accident claim. And then, my lord, now they have suppressed that material.
It's unfair to ask adjournment. 19 finally next week, no further adjournments.
Obliged, my lord.
Where is your advocate?
My lords, in fact, I've spoken to the advocate yesterday. Your lordships may have it after 10 days, we'll file a joint memo and report settlement.
Why the advocate is not representing?
No, my lords, she called me yesterday.
Why are you engaging an advocate who don't represent you?
No, maybe some emergency, she could not come.
Last week also you said the same thing.
Sorry for that, no. No, yesterday we actually spoke.
I don't like these matters to be listed every day and adjourned without any basis. And if both of you are not interested, I'll delete it from partner and do whatever you want before the regular bench.
Submission, earlier advocate's name may be deleted.
Huh?
Earlier advocate's name may be deleted. I have already filed memo with that way. My name may be deleted.
For the respondent, delete the name of Mr. Ajay T.
Ajay T and Aruna Bhatt. Both.
Your name is not there in the list.
Ajay T.
Delete the name of Mr. Ajay T.
My lords, may
As
I
already
request my lords
another
to have it on
advocate has filed the wakalat.
May I request my lords to have it on 24th?
Yes, 24th. I'm telling on 24th, if the joint memo is not coming up, I'll delete it from partner.
Obliged.
Serial number 2. Vasudev Murthy for appellant. Yes, Nagesh.
Who appears as the respondent?
11-year-old boy.
Nagesh. C.S. Sridhar.
The land counsel for the appellant is present. No representation on behalf of the respondent. Delete this matter from the caption dismissal. List it as partner tomorrow.
Tomorrow.
When you want.
Yeah.
Yeah,
Otherwise
tomorrow.
Monday.
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 Yes, next.
Wait, this number, serial number 3 adjourned. Serial number 4. Serial number 4.
One for the respondent, my lord.
Raju.
Give that file. This matter is listed before the court for non-filing of the necessary application to bring the LRs to the deceased R2. On 6/1/2025, there was no representation on behalf of the respondent, on behalf of the petitioner. Again, when the matter came up on 10/3/2025, even on that day also, there is no representation on behalf of the appellant. It's a matter directed to be listed under the caption dismissal. Today also, there is no representation. It appears that the appellant is not interested to pursue the matter, accordingly dismissed for non-prosecution. Next.
Serial number 5 adjourned. Serial number 6. Suresh Latur for appellant. For appellant.
Give that.
We have filed the dispensation of R1 and R3.
Memo is for seeking dispensation of notice to respondent number 1 and respondent number 3 as a place ex parte before the law court. Memo is taken on record and notice to respondents 1 and 3 is dispensed with at the risk of appellant. List this matter for admission.
Serial number 7. Serial number 7. Shri Harsha, yeah.
One of the connecting cases. MFA 4453.
No, first of all, MFA 4454, who represents? Non-furnishing of PF to issue notice to R1 for the first time.
For R1, I will file vakalat because my name has been shown
For
already.
R1
If they give copies,
When already Mr. L. Srikanth Rao had filed his wakalat, then counsel for the appellant in MFA 4454 of 2016 shall serve the copy of the appeal memo on the counsel during the course of the day. Then what about
I'm sorry. Still have to file vakalat. I have not filed.
wakalat? He submits that he is appearing for respondent number 1 and he'll file the wakalat. Next, what did you say? What is other matter?
No, my, no, my lord, the same matter.
Same.
Same.
MFI 4860, it's there already.
Yes, yes,
Yes.
already connected.
This,
Tell number.
this is matter of 2 weeks.
Lordships, one submission, your
Yes.
lordships. In the previous matter six, I'm extremely sorry to interrupt, and for R2, your lordships,
In which case?
serial number 6, my lords.
Uh,
In that, the memo, they had filed memo for dispensation of notice, my lords. They are seeking as there is no liability. And for the insurance company,
They sought the dispensation to R1 and R2.
as there is no liability, my lords. So, but the same may be recalled, my lords, because
What recall?
it may be not dispensed, my lords. I request.
That's their problem. If they're doing it, they're doing their.
Because there is liability, my lords. That is the reason that there is liability according to us, but they are seeking for dispensation as there is no liability. So that is the reason. So this matter may be
I'm not able to understand. You appear for whom?
for the insurance company, R2.
Correct.
So it may be not dispensed, my lords. I'm requesting.
R2 it is not dispensed.
For R3, or
R3 is who?
the private party.
So what is your problem? That is his appeal.
It may be not dispensed or.
You cannot ask for that. He'll be doing it at his own risk. Yes, next.
Yes.
Yes, next.
Serial number 8. Serial number 8. R. Chandrana.
In one matter and responding in another matter.
He appear for the respondent.
Bringing a loss of this.
5554, I am for appellant.
No, I think
The
that's
claim-
not the number at all. There is
Tell
no
number
such
8, sir.
number here.
8619.
8. I appear for the appellant. I
That is-
was directed to serve copy on Mali Patil and Pradeep.
No,
As
his name is R. Chandrana.
order, yes, ma'am.
R. Chandrana.
Yes.
Not taking steps in respect, in bringing LRs of the deceased R1. That
R1 is not dead. R1 is appellant in another matter. I was directed to serve copies on the advocate.
No, for example, if R1 dies, if R1 is no more, are you not supposed to file the LR petition?
R1 is the appellant in another matter. He is continuing. Mali Patil is appearing for the appellant. Nisarga.
He has to file a necessary application in that case also. You have to file an application in your case.
On the last date, I was directed to serve
This
copies,
is where is the other connected matter? What is
Pardon?
the number? Connected matter number.
connected matter. 5295.
Take that number, list this matter along with that. Day after
That is
tomorrow.
also listed today. Today,
Serial number.
I think there is some
5295.
confusion. Huh?
Mali Patil.
No, I think you're confused. You're referring to some other list. List number 2 you're referring to.
List number 1, serial number 8, R. Chandrana.
8 is R. Chandrana. There is only one matter.
8619. Only one matter is there.
This is connected with another matter, 5295 of
That's not
2019.
there in the list today.
2019.
Take that list along with that to day after tomorrow.
That is by the owner.
It's not there in the list today.
14.
Yes, next matter.
Serial number 9. Nagaraja K.
Serial number 9, my lord, I appear for the KSRTC appellant. There are about 7 appeals. I am ready, my lord.
In this case, what happened, man, the claimants has filed the cross appeal in 68 to 90, 68 to 73. In this case, I have to serve the copy of the.
He doesn't want your copy. He's
Yeah.
ready with the case. He is not asking for copy. Why are you bothered?
This is
Yes,
club,
he's ready with the matter.
is clubbed, but I have not served the
Huh?
copy. Connected with the appeals.
No, he's not asking for it. Why are you bothered? He's ready to argue. You argue the matters.
Kindly have it tomorrow, please, man. Tomorrow, please. At request, man.
Please see your number of matters are listed
Please.
today. How many?
Total
number?
7 plus 7, 16.
12 matters.
12, 14,
Ah.
14 minutes.
14 matters.
One matter is reaching within another court. There is suspension of sentence application is there for tomorrow. Without fail, I will do it, man, please. Tomorrow.
What you have to understand is earlier court has given 60 matters a day. The
Yes.
date
Others
given
kindly
matters-
pass over, kindly pass over.
Yes, pass over.
Please, ma'am. Probably time 2:30.
230, my lord.
Yes.
Please, ma'am.
Serial number 10. Substituted service. In Hosadiganta daily newspaper.
So and so, application I number 1025 is filed, the substitute service of notice on R2. In which paper?
Hosadiganta Daily Kannada newspaper.
So and so accordingly, the IA number 1 of 25 is ordered, permitting the petitioner take out notice in so and so daily on or before
25-3, hearing the.
mentioning the date of hearing as so and so. Yes, next.
Sale number 11, Hosadiganta, Davangere edition.
Yes, 13,
Same.
12.
Sale number 12, D. Vijay Kumar,
I have respond claimants, ma'am.
Gopal Krishna N.
My lord, I am for the appellant in the first matter, my lord. There is a delay of 76 days in filing the appeal. Delay may be controlled.
Will condone the delay, Mr. Counsel.
Please,
Gopal
ma'am.
Krishna.
Please, my lord.
IA number 1 of 16 is filed to condone delay of 76 days in filing the appeal. Accordingly, the delay is condoned. This is matter for admission tomorrow.
Records may be put up, my lord.
Huh?
Records.
Required.
Give a date.
14.
Yes.
Sale number 13,
Records are available, my lord.
Kannada Prabha.
Call for the records telephonically. Yes.
Much obliged.
Yes.
Sir, 14.
Serial number 13, my lord.
There is a delay of 173 days.
Yes. Who appears to the respondent?
Arini Shivanand.
What do
I
you say?
for the respondent, my lord.
What do you say? Have you filed your objections? Will condone the delay.
Condone the delay with no interest, my lord. It's a WC matter.
170 days,
In case of death, my lord.
not an inordinate delay. The IA number 1 of 17 is filed to condone the delay of 173 days. The court had perused the reason stated, in the accompanying affidavit. Then counsel appearing to the respondent insurance company submits that the delay may be condoned, but however, they are not entitled for interest for the said delayed period, considering the fact that it's a case of death and 173 days delay is not an inordinate delay. Accordingly, I number 1 of 17 is allowed condoning the delay of 173 days. This is matter for admission.
Maybe disposal of only income, my lord. 8,000.
Only income is, I'm ready, my lord.
4,000.
What is the amount claimed?
Amount claim, my lord, 8,000 rupees, my lord, income and 200 rupees bata.
Huh?
200 rupees bata.
How much the court had taken?
Tribunal trial court has taken 4,707, my lord.
1,000?
4,707, 707. So 8,000 has to be taken, my lord.
My lord, in this case, para 17 of the judgment may be looked into, me.
It's arising out of the workman compensation.
Please, madam.
Yes, my lord. Para 17 of the judgment, they file a memo stating that the petitioner was receiving 4,707. They file a memo to that effect.
Then why should we take otherwise?
In the absence of income, my lord, it has to be 8.
Absence of income.
No.
You file a memo saying that this is.
I petition, I'll kindly see, my madam. I try claim petition is I claimed that my 8,000 rupees and 200 rupees bottom, my lord.
Please come to para number 17.
Please,
Read
madam.
it. In the case on hand, the learned counsel appearing for the petitioner filed memo dated, duly signed by him. It is part and parcel of the petition, wherein it has been stated by the counsel the deceased was getting salary of rupees 4,707. When you admit that your salary is
In the absence of
4,707.
the amount, my lord.
Absence, there are two things.
Please, my lord.
Absence of evidence is altogether a different factor. When
Even, my lord, claimant has claimed lower income, my lord. It's the duty of the tribunal take the 8,000 rupees income. That is the judgment of a.
to show the judge.
This, my lord, section 4, my lord.
Courts will not go beyond the pleadings of the parties.
The claimant must be awarded in full amount of compensation under section.
Whatever is the amount you are getting, you have said so.
Under section 4, if they claimed a lesser amount.
Why? You are saying that it is your
Well, that
income. There is no dispute on that.
No, my lord. This is now Act is amended.
Compensation.
Before the.
Claiming a lesser compensation is a different aspect. And saying that this is my income is altogether a different aspect. Why should the court do the exercise when you yourself say that?
I go through that memo, my lord. I don't have a memo, my lord. Go through the memo.
And it will not be enhanced. List this matter day after tomorrow.
With your lordship kindly, my lord, previous matter, my lord, tomorrow I will not be in station. Kindly have it some other day.
When is it? Tomorrow it is not posted.
Yeah.
When is it posted?
Your lordship said tomorrow, that's why, my lord.
Tomorrow
The
is
records
14th.
have to come.
This is matter on 19th.
Established.
Previous.
Yes, next.
Serial number 14. Appearing appearing for the appellant, my lord.
I have a note ready for his file for seeking substitute service of notice. So and so. On or before mentioning the date of hearing as so and so. Yes, 15.
15 same.
Yes,
R2.
yes, yes.
Serial number 16 urgent, serial number 17.
Yes, Mr. Chandrasekhar.
I pay for the respondent, my lord. Copy
I
served.
have served on you.
Yes, my lord. It
Are
can
you
be
ready?
disposed of.
Yes. I am ready, madam.
Oh, yes, argue.
It's in, for enhancement, the appeal has been filed.
What is the amount granted?
Amount granted is 60,360, madam.
16,000?
60,000.
60,000?
60.
066.
60360.
360. It's a case of injury.
It's a injury, madam.
How many simple injuries and how many grievous injuries?
My lord, I say almost all are grievous injury. Kindly see para 8 of the judgment. Has been extracted. Seven centimeter inside wound over left petriole, left side temporally bone fracture, frontal bone fracture, multiple right and fifth finger proximal fracture. For all this, court has awarded, tribunal has awarded 34,000. That loss of income only has been taken and that has been. at the
Pain
date
and
of court-
agony, reasonable amount is granted. What is this fresh 15, no, will, one grievous injury. What, altogether 3 grievous injuries.
3.
Medical bills, any dispute?
Medical bills
No.
have not put in that is the risk.
How many days was in hospital?
No
say
record
more
to show that.
No records have been produced in the trial court, but I say more than 10 days he was hospitalized. The court has taken loss of.
Which year is the accident?
My lord?
Which year is the accident?
2011.
2011, 19/1/2011.
How much you have claimed that is your income?
Income 8,000.
Huh?
8,000. per month.
According to you?
Yeah.
2011 means 6,500.
Doctor is not
6,500.
examined.
Huh?
Doctor is not examined.
500 into 3. $91,910.
Okay.
Please come. Agreed with orders passed in MSC number 2314 of 2011 dated 28 July 2012. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees. How much was claimed?
Claim is 15 lakhs.
seeking compensation of 15 lakhs for the injuries sustained by the claimant in the road accident that took place on 19/1/2011. It is a case of the claimant that he was riding the motorbike on Siddhalagatta road of Chikbalapur. At that time, the driver of the tractor drove the vehicle in a rash and negligent manner and dashed the motorbike. And as a result, he had sustained injuries. He had sustained 4 grievous injuries. Initially, he was admitted to the Chikbalapur Government Hospital and then to Nimhans Hospital, Bangalore for treatment. He had spent ₹1 lakh for medicine treatment, conveyance, and another sum of 40,000 for attendant charges and for food and nourishment. And according to him, he was working as a driver and earning 8,000 per month. The court has considered the wound certificate, which shows that he had sustained 3 grievous injuries. However, the court has observed that he has not examined the doctor, and towards pain and suffering, the court had granted $34,000. Was medical bills 12,410, conveyance, food and nourishment 3,500, taking the income at 150. Taking the notional income, court had granted 450 rupees. Loss of amenities, an amount of rupees 10,000 is granted. I have not calculated that. Then it will become 1,01,910. Then counsel appearing for the claimant submits that the court ought to have granted a reasonable compensation. And the wound certificate clearly shows that he had sustained 4 injuries. On the ground that the doctor was not examined, court had granted very minimal amount. Further, the income was considered at 450. The 3 grievous injuries when there is also a fracture and when the petition is working as an appellant is working as a driver, a loss of income should have been considered appropriately. And for those injuries, as he was in hospital, court granted only 3,500 to his conveyance, food and nourishment, which is on the lower side. As such, the compensation needs to be enhanced. And counsel appearing for the respondent insurance company submits that court, considering the evidence on record, has rightly considered and granted compensation. Though he has filed a wound certificate, he has not examined anyone. He has not examined the concerned doctor. And as such, the compensation that is granted by the court is just and reasonable, and no enhancement is required. Next, for having heard the counsels on it, there is a material on record. The court had considered the wound certificate and the fact that he has sustained 4 injuries. Considering the same, this court is inclined to grant an amount of ₹40,000 towards pain and suffering. Medical bills, there is no dispute on that. Then 12,410 is granted towards conveyance, food and nourishment. Considering the injuries, this court is granting an amount of ₹10,000. Then coming to loss of income during the later period, considering the avocation of the petitioner and the accident is of the year 2011, 6,500 is taken as income, and for 3 months, 19,500 is granted. Towards loss of amenities, the trial court had granted 10,000, and this court is not interfering with this. In the light of the law laid down by Honorable Apex Court in Mekala versus so and so, an amount of 10,000 towards legal expenses altogether, the claimant is entitled for 1,01,910. Accordingly, the is partly allowed, enhancing the compensation from so and so to so and so. Next.
Cell number 18. O Mahesh for appellant. Manjunath Pattan Shetty.
I appear for the appellant.
The counsel for the appellant is present, no representation for the respondent. Admit also matter for final hearing, give a date. Next, 19.
Cell number 19. Cell number 19. Lokesh Ake,
Thank you,
This is the counsel for the appellant. You're for the appellant.
please.
Pass over. There is Mr. Respondent, you're ready?
Arvind M. Neglur,
Land counsel for the appellant is present, no representation for the respondent. Admit this matter for final hearing.
cell number 20, O Mahesh for appellant.
My ladyship, I'm appearing for the respondent in this case. The appeal might be disposed of, as in the connected matter, the honorable court has held.
Yes, you wanted to look at that, Mr. Mahesh.
Yes, my lord.
Last occasion when the matter came up, she has relied on some order in a connected matter.
Yes, ma'am.
Yeah, yes, my lord. That is a MFA.
2798 of 2020.
2798 of 2008, my lord, that based on the Mukund Devagan case. Now, my lord, the Supreme Court, my lord, has not said that the Mukund Devagan case is right, but only thing is suggested the government to make amendment. That would mean, my lord, that
So even till now,
yeah.
as long as the amendment comes into picture, we have to follow Mukund Devagan. So coming to the facts of the case, it's only you're on the liability.
Mainly on liability.
Then
It's a
we'll apply the
simple
same and next come. MFA number 2799 of 2015 and MFA 2799 arises out of MVC number
798 of 2012.
798
798 of 2012.
of 2012.
12.
And the other one?
MVC 800 of 2012.
800 of 2012.
Yes, madam.
MFA number 27999 arises out of MVC number 7981 of 2012. And MFA number 2800 of 2015 arises out of MVC number 7800.
No, ma'am. 800. 800.
There is no common order.
The common order was in, they were all connected together. See, on the last date, I've also produced the.
One is
One is
798, not 81.
798.
The 798 and the other one
800.
800 of 2012. The trial court, by way of a common order, had disposed of these appeals. As such, this court is also passing a common order. The insurance company is before this court questioning the liability on the ground that, which para of the order?
Lord, Mukund Devagan case, Lord, based upon the
No,
Mukund Devagan case.
The finding of the court.
Para 8 in the High Court, ma'am.
Para?
8 of the High Court judgment.
No.
In the trial.
In this order. With regard to the liability. When it comes to the liability, the trial court had observed that a perusal of the evidence on record, the tribunal has observed that a perusal of the evidence on record discloses that RW1, the deputy manager of the second respondent insurance company, in his evidence has not stated the fact that the driver of the insured auto rickshaw had no driving license to drive the same at the material time of accident. Hence, the second respondent has not led any evidence in support of the defense taken by it. On the other hand, Exhibit R1, the notarized copy of the driving license, which was marked with consent, discloses that one Krishna, the driver of the offending auto rickshaw, had valid and effective driving license to drive a three-wheeler auto rickshaw. The court observed that the second respondent has not disputed the contents of Exhibit R1. Hence, the contention of the second respondent that the driver of the offending auto rickshaw had no driving license to drive the same on the material time of accident cannot be accepted, and accordingly held that the insurance company is liable to pay the compensation. Learned counsel appearing for the insurance company submits that the tribunal held in holding that the insurance company is liable to pay the amount when it was specifically pleaded and proved that it is liable since the driver, it is not liable since the driver of the insured transport auto had no valid and effective driving license authorizing him to drive a transport and admittedly a DL for LMV non-transport, which was issued to him for the first time on 27/10/2009. Land Council submits that now the Honorable Apex Court in Mukund Devgan's case, while considering the Mukund Devgan's case, has directed the government to make the necessary amendments. That itself shows that the Honorable Apex Court has not approved the law laid down in Mukund Devgan's case. As such, the insurance company is not liable to pay the compensation. Learned Counsel appearing for the claimant had relied on an order passed by this court in MFA number
2798.
in MFA number 2798 of 2015 and MFA number 8205 of 2014, arising out of the same accident, wherein this court had applied has held that in the light of the Mukul Devgan's case, insurance company is liable to pay the compensation. In that view of the matter, this court finds no reasons to interfere with the well-considered order passed by the trial court. Accordingly, MFA number 2799 of 2015 and MFA 2800 of 2015 filed by the insurance company are dismissed, and the amount in deposit shall be forthwith transferred to the trial court.
Much obliged. My lords, can you direct the LCR records to be sent back because they want
It will be sent, that will be one of part of the order.
Much obliged.
Yes. Next.
22. Cell number 22.
This M. Narayanappa.
The appellant, my lord.
Oh.
Since Naranappa is no more, the file is transferred to me, my lord.
Huh.
It's appealed by the insurer. Claim under Compensation Act, my lord.
Hmm.
Appeal on liability. There is
Workman
no,
Compensation Act.
my lord.
Workman Compensation Act.
Please, my lord, please. Appeal on liability. There is no employee-employer relation is proved by examining the owner.
Let's see the finding of the trial court on that.
My lord. Huh? No, how's it? Leave it. So the learned judge at page number 6, para 12, admitted that first as a file return statement, no records is filed in the.
Which para you're reading?
Para number 12, my lord.
Let's read.
In this case, first respondent has admitted that the petition was the driver of the working under him. Though second respondent denies the petition.
Second respondent is the insurance company.
My insurance.
On what basis you deny?
There is no relationship between, he is not employer-employer relation is proved by the claimant. There is no.
So when the first respondent himself is admitting that he is my employee.
No, only, not even filed, we could not get even written statement in the file.
In this case, the first respondent has admitted that the petitioner was a driver working under.
There should be written statement in the file. There is no.
So the second respondent denies the petitioner.
Not only written statement, only filing the statement.
Then what is, no, petitioner says he's working under him. First respondent
Yes,
admits that.
Yes.
What did you do? What did the second respondent do?
No, we have filed my objection statement. We are stating that there is no employer-employer relationship.
Simply denying it.
My lordship.
Simply denying it. First respondent is admitting that he is an employee.
Not only that, my lord, apart from that, the learned judge taken 50%, 25% of the disability for the petitioner.
No, that is the second aspect.
Yes.
Now we are first on the liability.
Yes,
so that is, there are no grounds. Then come to the compensation. Please come to that.
No, the claimant himself is charged sheeted for the wrong filed, wrong by him. There is an accident between two-wheeler as well as the car.
Where is the question of negligence here?
No, he was charged sheeted by the police, taking into cognizance that he is only the tortfeasor. He has been charged sheeted. And further, my lord, I pray this court to give me a 2 weeks time. Secure the records. The entire records are in Kannada. I will translate it before.
It is a MFA of 2017. What is now the translated copies and all?
No, 2 weeks time I kindly granted. Secure the records. I will place it before the court.
Finally, 2 weeks time is granted.
M.
The request of Land Council for the appellant. Yes, next. Delete the name of so and so. Yes, next.
List number 2, serial number 1.
Yeah, progress.
Gopala Krishnamurthy.
Respondent to lordship.
Appellant.
Give that file.
My love, I'm for appellant. My senior very good hall. ನನ್ನ ಸೀನಿಯರ್ ಬೇರೆ ಕೋರ್ಟ್ ಹಾಲ್ ಇದ್ದಾರೆ, ಪಾಸ್ ಹೋಗ್ಬೇಕಾಗಿತ್ತು.
Your senior is in another court. You have to comply with the office objections. You don't comply with the office objections. It's a MSC of 2023. IA 1/25 is filed to recall the order dated 15/11/2024. There are so many things. Delete from caption, dismissal. This is matter on Tuesday. Yes, next. Yes, next.
For orders matter, sale number 3, 2. Sale number 2. Matri Muhammad Ismail Karim Saab. No for acknowledgement. Non-furnishing of air mail.
No representation. List this matter for dismissal. Give some date. Yes, next 3.
14. Sale number 3. JJN.
For the respondent in this.
Matter is settled.
Settled mediation.
See that report.
Fishes.
For the respondent.
Where is the other side?
Maybe it maybe vacate the stay.
Huh?
Maybe close the.
Vacate the stay. It's already settled.
side,
How
no.
does it matter now?
Yes.
We'll take it up tomorrow.
Tomorrow, maybe close and
That side.
Other side should also be here when passing an order.
because she is coming from hospital, but other side advocate is here only, but
Where is advocate? I'm asking about the advocate.
he is not yet come.
Sale number 3. Ajay J. Nandalike.
We'll take up this matter tomorrow.
Not yet told, maybe closed and
Again, don't repeat the same thing. List this matter tomorrow. No representation for the petitioner. Yes.
Sale number 4. Sale number 4. Then Krishna Swami.
No representation.
Serial number 3, my lords. I was stuck in the
3. Call him.
compromised, my lords. The divorce decree, the divorce proceedings also has to be withdrawn, my lords, if that may be recorded according to the
Where is
compromise.
the compromise, the report of the mediation?
put is
center?
there,
Please go.
CP, that is it.
I was stuck in the.
Okay. Agree to pay 25 lakhs to the petitioner.
Why don't you file a joint memo before this court?
Yes, my lords, we'll file a joint memo.
No, that will be,
And
that,
in office,
huh?
we'll file office in,
We'll file it in the counter, my lords. It may be listed any day next week, my lords, before, my lords.
This is
We'll-
matter next week, give some date. By that time, the parties shall file a joint memo. It is stated that already the
It is-
disputes are settled between the parties.
sure.
Sale number 4. Krishna Swami.
No representation for dismissal tomorrow. Give the date. Yes.
Number 5.
Appear for
Shardamba
I
A.
appear for the appellant, my lord. I have made an
Proposed
application.
respondent is the beneficiary. Same matters.
My lord, but one time submitting is that.
IA may be
No.
allowed
Allah
and
and
then the matter may be remanded.
Yes.
the IA may be allowed, my lord, so that my name may be shown in the this thing, so that I will, after getting the order passed by this honorable court, I have to render my opinion as well. Otherwise, nobody will in the
No,
reference
in
court
the-
and other,
The connected matters court said,
yes.
no need to implead him here. He can be impleaded before the reference court. So why should we pass that order? That I'm not able to understand.
No, my lord, in all the.
In all the matters, that's
In
all.
all the matter coordinate bench
As per the
has
same order.
allowed the petitioner to amend the petition.
No, the other day I've seen, I passed that order in that it is not there. He said
No, no.
petitions are at liberty to plead the beneficiary before the trial.
No, my lord.
reference court.
Uh,
That's the order.
No, IA is filed, my lord. my submission.
IA is filed, what
Yes.
I have recorded in the IA earlier also.
Yes.
IA number so and so is filed to implead the beneficiary, which was not impleted. The appellant is at liberty to implead the beneficiary before the trial court as a matter
No,
of
that is
being
no problem.
remanded.
The problem is that suppose if this honorable court is not going to allow this application
It's a
and
direction.
come on
We
record.
cannot- May submit, my lord. We cannot come on record, my lord, because our name will be showing in the cause list. We have proposed respondent. Our name will be showing the cause. But in the order, my lord, as the proposed respondent is not impleaded in the order, our name will not be shown. And we cannot take this order and.
We cannot.
You don't have to tell. They will file an implead petition, then
My lord,
this will be served on you.
I will submit, my lord. The problem is that in all the places, my lord, once they impleaded, the notice has to be ordered. And if this honorable court direct stating that both the parties has to appear and none of them will appear on behalf of the beneficiary, then again the same problem will be repeated.
No, why you are not objected in the other case? When that was ordered?
Yesterday I made my submission.
Not your submission in the earlier order. I'm saying, in the earlier order that is passed by Justice Anchate Sanjay Kumar.
No. Yeah, you have been impleaded in that matter also, my lord.
The Kaveri Niravari Nigam's cause title is shown. And
where is that order? Let's see. In that it is not. Look at it. They are at liberty to implead. That's what is the order. Yesterday it was given to me. Passed on to me.
In another case of mine only, my lord, MSA 112 of 2017, similar order. There also, my lord, I have made an application. It was allowed.
That is
and
what.
They were impleaded, and the operative portion, my lord, that order of the court below was set aside, and the matter is remanded back to the trial court. And they are permitted.
That I understood. No big loss is going to either cost you or cost to them.
My lord, one submission is that, see, once we impleaded and we get the copy, we have to send the Kaveri Niravari Nigam and address with this honorable court. And we have to be very careful. The time period will be only 6 months or 3 months, whatever it is going to fix by this honorable court. And to direct the respective council, they have to follow up the matter. And otherwise, my lord, what has happened, I'll submit, my lord. Beyond the back of the beneficiary, so many orders have been obtained. I'll make submission. The problem is that it has created a lot of problem. In Tumkur, my lord, for neither the land acquisition officer nor the beneficiary, they have not made party. And for the one mango tree, my lord, 1990 acquisition and 1,01,055 rupees has been ordered. And whereas and others have prepared the appeal by relying on those documents. Before this honorable court also, coordinate bench has passed the same order stating that we are not prepared an appeal and it has, again we have to rush to the honorable Supreme Court, all these things. That is the problem. So in view of that, let the impleading application be allowed and your lordship can pass an order. Then we'll direct the managing director to follow up the matter before the concerned courts, either in Mandya, Asana, or wherever it is. That is what my submission, my lord.
At that point of time, my lord, there was no beneficiary. There was no Kaveri Niravari Nigama as on the date of acquisition.
We are making it all complicated.
Yes.
It is very simple.
That is
Just leave it. MSA
please, my
number
lord.
111 of IA number 6 of 24. In MSA number 111 of 2017, give the file. IA number 6 of 24 is filed to implead the proposed respondent as R2. Proposed respondent is the beneficiary. At that point of time, when the land acquisition proceedings were initiated, there was no entity called the Kaveri
Niravari
Nigam Limited.
Kaveri Niravari Nigam. As such, the present application is filed. In all the connected matters, the order passed by the court is set aside, by the reference court is set aside, and the matters are remanded back to the court for fresh consideration. It is submitted by the land council that the IA that's filed may be allowed, and they may be brought on record as they may be brought on record as respondent number 2, and they will take further steps. In the other connected matters, yesterday you only have taken that. In the other connected matters, where this court has passed an order permitting because when the matter is being remanded to the court, this court has permitted the appellant to implead the beneficiary before the trial court. And they has directed the appellant to implead the beneficiary before the trial court. In that case, there is no need to order IA number 6 of 2024, impleading the proposed respondent. As such, this court is passing the following order. The order dated so and so, passed by the reference court in so and so is set aside, and the matter is remanded back to the trial, back to the reference court. The reference court shall dispose of the same within 6 months. All that clauses which are incorporated, same clauses. Yes, next.
Court fee may be refunded, my lord.
Huh?
Court fee refunded.
Everything, please.
Much.
Yes,
My lord,
next.
come to submission, my lord. Serial number 4, my lord.
Where are you?
Held up in another.
Yes.
Requesting for 10 days, my lord. The case file is misplaced. my
Already
lord.
court has passed an order on 14 to 2025. And again, you're seeking time.
Another
Finally,
10 days, my lord.
in item number 4, finally, 10 days time is granted. Yes,
Much
next.
obliged, my lord.
Huh? Yes, next.
Serial number 6,
Happy for responding.
14,
For respondent number 2, my lord. My lord, I have to file my objections, my lord, in this case.
What is this RP?
RP.
serial number 6, MSA.
Oh, it is 6. Yes.
I am for the appeal. I have to
Proceeding.
file my objection for
For this
respondent number 2.
1179.
Please, ma'am. I will file my objections.
How much time?
2 weeks time, my
That
lord.
counsel appearing for the respondent. Number 2 seeks time for filing objections to and number 1 of 2018. A 2 weeks time is granted.
Please.
Next number.
7,
Not insurer apply and liability, insurer petition liability, please not. There was no DL. You have let the evidence before the tribunal. Owner filed an appeal. In appeal, a liability fixed against, though there is no DL.
Huh?
ಇದು Justice Shivshankar got to pass an order, please.
The order notice.
Please, not.
Notice.
Note, one submission. Kindly permitted to serve the copy and the first respondent in the review petition, please. He is the appellant before in the appeal, please. Kindly, I will take out the notice to the second respondent and filing a memo for 3 and 3 is the driver of the vehicle, 4th is dismissed again.
Memo is filing a dispensation of notice to respondents 3 and 4. Accordingly, memo is taken on file and the notice to them is dispensed with at the risk of appellant. As far as 1 and 2 are concerned, the petition shall to whom you will serve?
Owner, the appellant before in the appeal, please, owner of the vehicle. Appeal filed by the owner, please. There is a Pascal Dice. I will serve the
There be a court notice.
advocate and record, please. N.R. Ravi Kumar.
In a RP again, we can't take that notice to the
One and first and second respondent.
Huh?
First and second respondent.
first and second registry is directed to issue notice. Yes, next date.
serial number 8,
Wife
Yeah.
petition, madam. Transfer petition.
Where is Renuka Devi? Counsel for the
KS,
counsel for the petition is present, no representation for the respondent. This matter as part heard. Yes, next.
date,
Oh. Yes, 10.
serial number 9, urgent, serial number 10,
Petitioner in this case, ma'am.
Service of notice to respondent.
It's held sufficient.
Held sufficient, yes. Seeking transfer from where
Taking
to where?
transfer from Bangalore to KGF, madam.
Bangalore to,
KGF. Kolar.
how much is the distance?
100 kilometers. 100 kilometers. Madam, already
Petition is filed by
the wife seeking for transfer of a matrimonial case, which is
Hmm.
filed for restitution of conjugal right.
Hmm.
Already one case for divorce was filed and that case has been transferred by virtue of order passed by this honorable court.
No, no.
Annexure E may kindly be seen.
Divorce filed by,
Divorce was filed by respondent. Wife, petitioner filed a petition for restitution of conjugal right.
Hmm.
Husband filed a petition for divorce. Earlier, I had approached this honorable court, my lord, and this court directed for transfer of divorce case
to where?
to KGF, same place. This case could not be transferred because, my lord, the annexure E order may kindly be seen. 2 cases in 1 petition she had asked for transfer. Therefore, only 1 petition was transferred. She is filing the second petition for transfer of this other case, which is still pending in Bangalore. In that case, my lord, he had already submitted no objection.
To that?
Annexure E may kindly be seen. At page
So
number
at a
40.
time, how can she file restitution and divorce?
My lord, husband filed for divorce. Wife has filed for restitution of conjugal rights.
No, husband divorce petition here.
Please, madam. She also filed here. She also filed the petition in Bangalore. Then
Why
she
is
had
she,
to,
why is she?
then she had to move to KGF because her parents are residing in KGF. And therefore now he has deserted her. She has to travel only for this case to
Which what is the CP number where her transfer?
Annexary, my lord, CP 218/23. Annexary, I have annexed that order.
Page number?
Page number 41. In fact, my lord, she had sought for transfer of both cases, but one CP is maintainable for only for one case. That was a technical reason. And
The husband had filed for restitution of conjugal right, for divorce, and the wife had filed MC seeking restitution of conjugal rights. Earlier, the wife had filed civil petition number 218 of 2023 seeking transfer of both the cases to KGF, stating that now she is residing with her parents there.
And she has a minor son, 3-year-old.
And also has a minor son aged 3 years. Earlier, the court had two transfers cannot be granted by way of one petition. Court had transferred the divorce petition that is pending in Bangalore to KGF. Now the present petition is filed seeking to withdraw the petition for restitution of conjugal rights filed by wife at Family Court Bangalore to the KGF. The notice is held sufficient to the respondent by order dated 24/2/2025, considering the fact that already the divorce petition is transferred and divorce petition is transferred and the wife is staying in KGF along with the minor child. This court deems it appropriate to allow this petition. Accordingly, MC number so-and-so pending on the file of the family court so-and-so is withdrawn and transferred to so-and-so. Accordingly allowed.
R.P. Sadashivappa for petitioner, Raghu Prasad B.S.
Yes.
For the respondent.
Yes.
May please. Petition by the wife seeking transfer of the matrimonial case filed by the husband at Bangalore to Tumkur, where she is residing.
Distance between the places?
My lord?
Distance.
Distance is about 75 to 80 kilometers.
Any children?
No children. She is residing with her parents.
MC of which year?
22. 22, my lord.
Petition is filed in 2024.
Yes.
What is the stage of proceedings as on that day?
At the stage of the cross-examination of
Then why the petition was not moved till such time?
my lord, we have filed it quite early, but of course listed late. Whatever it is, my lord.
Stay is
sometime.
granted
Now,
when?
what has happened is
No, stay is granted when?
stay was granted. Stay is granted.
When?
In the beginning itself on 25/10/24 itself. No,
What
it's
has
not.
happened is, may I submit?
Huh?
We filed, Lord, the marriage sustained only for a period of 3 months.
Huh.
Then she deserted and went back. She filed a criminal complaint in the year 2021, 498A. Though we were living separately, she filed it against my aged mother also. We approached this honorable court and the criminal proceedings are stayed. Then, my lord, I filed MC in the year 2022. At the stage of my evidence, my lord, an application came to be filed by the petitioner herein seeking maintenance. The honorable court was pleased to grant them maintenance at the rate of 10,000 rupees per month. That we challenged in a writ petition, my lord, which was modified, saying that 5,000 per month till disposal of the writ petition. That we are paying. In the meanwhile, after passing of the order before this honorable court, she approached Tumkur court, filing criminal miss, claiming maintenance once again. Based on that, they have filed this petition now, seeking transfer so that MC petition goes to Tumkur. It's an afterthought, and she is claiming the same relief before the family court as well as in the criminal proceedings.
Yes.
So there is no bar for filing 125 proceedings and at the same time seeking maintenance before the family court also. Now, one petition is pending before the family court at Tumkur. I only invite my lord's attention to section 19 of the Family Courts Act, wherein
No, we are not on that point.
Yes.
I am on the point From 2022, you contested the matter till 2025 before the very same court. What are the now when the trial has already commenced before the family court? At that point of time, how can there be a
Look,
transfer?
She was not coming to the family court Bangalore for the reasons.
But she had
Because
the maintenance from the court.
even maintenance also, my lord, we are not getting it because they have, now it is reduced as submitted by learned counsel. Out of 10,000, 5,000 only is ordered because stay order is there in the writ petition. Even that 5,000 he deposits there. That is what he said. Of course, we have not verified it. Straight away, I make it a point. But that we cannot withdraw it because he has taken stay here. Therefore, in the circumstances, neither I got maintenance nor any other source of income. Though he says I got income, I have no income. I am residing with my parents. He admits that my father has suffered orders under Section 138 of the Negotiable Instrument Act. He has also produced us those orders also. We don't dispute it. Therefore, he also has no source of income. Though he was doing some business, that is not sufficient even for maintenance. To travel every time, it is difficult for now because the evidence has commenced, as I put it. She cannot come to the Bangalore every time, leaving the parents there, with none to look after them also. And the only child and no other is there. Under these circumstances, we have pleaded that the one petition is already pending before the court, family court, Tumkur. That is 125 proceedings. He will come there. At the same time, this will also go to the same court. It will be convenient for both of them to attend the cases.
Yes.
Lord, may I submit, Lord? Lord, the respondent may not take me as making statements against him, but the order sheet that we have produced at page 32, Lord, shows that she has been present before Bangalore court on all dates.
Page number?
Page number 33 onwards, my lord. Annexure R6 along with my statement of objections which I have produced, which clearly shows, my lord, several attempts were made even for mediation. And my lord, I have produced material to show that she and her father have received a sum of 6 lakhs from me, cash. That there are conversations in WhatsApp. And my lord, she has retained jewelry worth 5 lakhs from me. So apart from that, my lord, we offered another sum of 4 lakhs, which would amount to 15 lakhs. But she wants a bounty for having lived with me for a period of 3 months. In fact, my lord, if the stay were not to be granted, the proceedings would have completed by now. It is for them to cross-examine my client now, and then it is their evidence. Hardly 3 or 4 sittings, my lord, the matter will get over. Her presence would not be required at all. For cross-examination, her presence would not be required. Her presence would be required only for her to lead evidence and then for her to be cross-examined. Only 3 dates, my lord, the matter could get over. Expeditious, even if an expeditious disposal is also given, that would tantamount to early disposal. Even if April 30th is given, my lord, there will be an order passed by the trial.
Yes, anything to you want to add?
Cruelty, my lord. She, in fact, attempted to commit suicide. It is all in the petition. Attempted to commit suicide. That is also his allegation. And it is a fact, not just an allegation. She was so much tortured during the period when they were living together. At the same time, we did not file any case for divorce because we never wanted a divorce. But when he has filed it for divorce, we thought it that we should contest it. And we are contesting it. Now coming from Tumkur every time is...
Unfortunately, you were continuously attending from 22 to 24. That's what the docket proceedings reveal. So when you were, when at an earliest point of time.
For mediation and other things we have to come, we have come.
No, even after that also. Now here the difficulty is, now the court has spent substantial time on this case. So now the judicial officer, whoever is there, now they are acquainted with the case. Now is it not the waste of judicial time? If you have come at earliest point of time, 100% without looking into any other factors, court would have considered. You have surrendered yourself to the jurisdiction. You have filed a petition for maintenance. Maintenance is granted. If you look at the docket proceedings as he is pointing out, every time you were there on all the dates. So what's the sudden difficulty for you? It could have been from the beginning if it is the difficulty.
My lord, situations change in life.
What did you say in the affidavit? Let us
What
see.
is the situation?
This petition? No, let's
Yes.
look at the petition. What did you say? What is the change circumstances? And how
But
you are
my lord,
not
all
able
these
to-
days, I may say now, she is not also keeping well even today. She has not come. So I asked her to come before the court. So many things for a human life, as my lord is not quite experienced. Therefore, at one point of time, you were to come regularly does not mean I could come even now, in spite of my suffering.
No, the general, this
I
thing
don't
is-
mind producing the certain medical certificates and also an affidavit why I'm seeking now. That she is not.
Let's see, where did you say, what did you say?
Of course, in the petition, my lord, is just a verifying petition, application that we have filed.
Even in the petition, Lord, except to say that she is a resident of
Yes.
Tumkur, there is no other averment made it.
That fact is not disputed because marriage
my
has
lord-
taken place. Just a minute. If you want to say, let me say.
Please come.
Marriage has taken place at Tumkur.
And 125 proceedings, my lord, it is at the place. We have just filed our objections. So the trial
Yes.
is yet to commence there.
Therefore, I thought fit to invite my lord's attention to section 19, which says jurisdiction lies at Tumkur. The first two clauses, my lord finds, the marriage was solemnized at Tumkur. Section 19 says, every petition under this act shall be presented to the district court within the local limits of whose original civil jurisdiction. The first clause is, the marriage was solemnized. It is not in dispute, it was solemnized at Tumkur. Number two, the respondent at the time of the petition, presentation of the petition resides. So on the date of filing the petition by husband for divorce, I was residing. It is evident from the petition filed by him itself, because slightly indicates. Then the parties of the marriage lost resided together. After all, they resided only for a few days in Bangalore. And immediately thereafter, because of the cruelty, she made an attempt to commit suicide. Then she went to Tumkur. Since then, she is in Tumkur. So first two clauses where the marriage took place, where she resided at the time of presentation of the petition, all, I may say, the petition ought to have been filed at Tumkur.
Please come.
I leave it.
The present petition is filed, seeking transfer of MC number 5 of 2022, pending on the file of the fourth additional Principal Judge Family Court, Bangalore, to the fourth of the Principal Judge Family Court, Tumkur, where criminal miscellaneous number 12 of 24 is pending. The petition before this court is the wife. The facts of the case are the marriage.
Will others-
23/11/2020.
23/11.
2020.
The marriage has taken place on 23/11/2020 at Tumkur. The parties were residing in Bangalore. They resided together for a period of 3 months. In view of the differences between the parties, the wife went to Tumkur, where the parents are residing. The husband has filed MC number 05 of 2022 before the fourth additional family court, Bangalore. The wife had the petition thereafter. On 8/1/2024, wife had a petition under section 125 CRPC seeking maintenance in criminal miscellaneous number 12 of 24. And the same is pending consideration before the family court at Tumkur. It is stated that the petitioner wife is a permanent resident of Tumkur, and it is difficult for her to travel to Bangalore to attend the case. Hence it is stated that the pending MC number 5 of 2022, pending on the file of the fourth additional Principal Judge Family Court, Bangalore, may be transferred to the court at Tumkur, where the criminal miscellaneous is pending. Then counsel appearing for the petition further submits that as per the provisions of the Family Court Act, the case can be filed where the wife is residing or where they have last resided. It is stated that they've resided in Bangalore for a very short time, and she is admittedly staying in Tumkur. As such, there is every reason to transfer this petition to from Bangalore to Tumkur, considering the inconvenience that is being caused to the wife. Next para. Then counsel appearing for the respondent husband submits that the petition is filed in the year 2022. Wife had appeared before the court from 2022 to 2024. She also filed an IA seeking maintenance, and the court had granted 10,000 as maintenance. Aggrieved thereby, the husband had filed a writ petition, and the court had reduced the maintenance from 10,000 to 5,000. It is also submitted that a 498A case is filed against the parents of the respondent, and thereafter when they filed a criminal petition under 482, this court had stayed the further proceedings. Then counsel submits that now the petition is coming up for the evidence for cross-examination of the husband. And on each date of hearing, her presence is not required. And if she appears before the court for her examination in chief and the cross-examination, it would be sufficient. And if the stay is not granted by this court, by this time the entire proceedings would have been concluded. He submits that there are no grounds to transfer the petition, except stating that it is inconvenient to her. Nothing else has been stated. And how she was able to appear before the court from 22 to 24, and how she had she in fact filed a petition and sought for an order. All these things were no reasons were revealed in the application, and no grounds are made of seeking transfer. Next one. Transfer, and the petition needs to be dismissed. Next one. Having heard the counsels on either side, peruse the material on the record. Whenever the transfer applications are filed before the court seeking transfer, generally, in the general norm is that the court will take into consideration the inconvenience that it caused to the wife, and it also differs from case to case. In this case, if the transfer petition is filed in the year 2022, stating that as she is residing in Tumkur, it's difficult for her to travel, the view of the court would have been altogether different. But this is the case where she has appeared before the court from 22 to 24, and when he's coming up with a petition in 24, what are the reasons made her to file this petition when she was conveniently attending the court between 2022 and 24 is not stated. And that apart, the judicial officer, as the learned judge, had spent considerable time on this case and heard the matter. And at this stage, after the trial has commenced, it is not appropriate to transfer the case from Bangalore to the Tumkur, considering the facts and circumstances of this case. Accordingly, this court finds no reasons to interfere, no reasons to transfer. Accordingly dismissed.
Maybe at least be given traveling expenses, my lords. It's not income at
The
all.
husband will pay that.
But it is only for 2 hearings, my lord. As I said,
Whenever she appeared. Whenever the
let
presence
her
of
produce the material, my lord.
whenever the presence of the wife is required, and whenever she appears before the court at Bangalore, the husband has to take care of the traveling expenses, and the husband shall cooperate for the speedy disposal of the case.
In fact, my lord, now the bus is free, my lord. The government has made it free for all the women, so she would not incur any expenses.
No, once she shows it, but it's a reasonable amount or not, that you can tell the court.
Let her, as I said, my lord, let her produce the material.
What I respectfully submit is, my lord, as I submitted to my lord, he is not giving the maintenance.
We have deposited, my lord.
What does
In
it
fact,
mean,
not
sir?
only that,
Submitted that as this court has modified the order of the trial court from 10,000 to 5,000, it
No.
is a submission of the land
As an
council that,
interim measure, matter is pending.
and as an interim measure, when an amount of 10,000 is granted, court has reduced it to 5,000. It is a submission of the land council for the husband that they have been continuously depositing the amount. The wife is at liberty to withdraw the same.
Please.
Yes, next.
Case number 12, Rangaramu V for petitioner, V. Sharat Kumar.
Here for the petition. In the last occasion, this honorable court other side has stated that the section 24 of the CPC, because within the district, they have to file it before the district court. But the wider scope is under the section 24 of the CPC. There is also decisions of this honorable court as well as
So
Supreme.
like, concurrent either to the district court or to this court, they can come.
Both have got power.
what we have been entertaining.
No, okay. So
It's
please,
all-
what has
it's all
happened
the
here,
other
please, Lord?
side submission. And also I've got two decisions of this.
That is not required. Now we will see whether the transfer is required or not.
On
What-
merits, please. Lord.
On merits, we'll hear. So
Yes.
what is this, you're seeking transfer from where to where?
From Nanjangud to Mysore, madam.
Nanjangud to,
Mysore,
what is the distance?
14 kilometers.
Huh?
14 kilometers.
MC of which year?
She is from the native of my.
MC of which year?
24.
24.
Only notice has been served in both the cases.
Will transfer.
You have got permanent resident of
petition
Mysore,
is by the
madam. The
husband.
parents' house is there.
This is by the husband.
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 And,
Please.
Wife.
and he is not also residing in Mysore. He is residing in, he is working in
On
Mangalore.
what ground it should be transferred?
Please, my lord, because your lordship kindly in the last occasion, I may permit to read only two sentences in the petition in which for the temporarily she is shifted to her grandparents' house. That is the,
She is the resident of which place?
yeah, she is
What has
permanent
happened?
resident of Mysore. Their parents are residing at Mysore.
We'll ask.
Please, my lord.
Please, Lords. After marriage, both were residing in Bangalore. She was working in Bangalore, he was working in Mangalore. Saturday and Sunday they used to meet, but here, even one day they did not stay together. And she went back to Mysore, but as she was working,
It is an admitted fact that in Mysore, that's a place of residence.
she's not residing there. She's residing now with the grandparents. What has happened after marriage?
Who stays in Mysore?
Mangalore, he is working in
Mysore, who stays?
Mysore.
Their parents are permanent resident of Mysore. Marriage was celebrated at Mysore. And she is
parents
working
were-
at the MNC company, work from home.
Why should you go to that place?
Please,
Family for Mysore.
You are
after
a working women.
working, now she's not working, please, at present.
You have a parent's place.
No,
That
please,
is
no,
Mysore.
please, Miss. She is not residing in the parents' place. After the marriage, she came back to Bangalore. Again, when she went back, she was not, the parents also said that you should go and leave the husband. Now she is living with the grandparents at Nanjangud. Nanjangud is only, as he said, 14 kilometers, half an hour drive in a two-wheeler for him. Not even half an hour. Very nearby place, please, Miss. She is now, earlier, at the time of filing the petition, she was doing work from home.
It can't be a difficulty because your parents are there in Mysore.
Please, Murthy, no, now she is residing and she has filed already earlier.
So tomorrow she'll go to her distant relatives'
No,
place somewhere.
she has filed a petition at earlier petition is filed by her for annulment of this marriage in Nanjangud. It is annexure. He himself has produced it. The marriage.
So what is the
petition.
material to show that she is residing in Nanjangud?
Please, Murthy, that has been.
Know that she is not working? Have you
No,
filed, an affidavit is filed stating that she is not working?
No, it is after the filing of the petition, she is unable to do the work, and as there is a dispute between she has filed earlier please notes for annulment of marriage, which has been.
Is she working or not?
I'm not aware of it. Para 6, para
I will,
17.
What is his qualification?
please notes. And please, miss, I am told that she has been relieved from duty and she is not working. Week's time is.
So a lady who is working in Bangalore, who is educated, will
No,
go
she
to
was
a remote place like Nanjangud and stay
doing
there.
work from home, please notes. Now earlier she was in Bangalore, he was in Mangalore.
When it is convenient to both the parties to have it in Mysore.
Please notes,
Why should she go? Why should it be in
please
Nanjangud?
notes, what has happened is, one of the ground is that impotency has been stated in, one of the ground is impotency, what has been stated. In Mysore, everyone knows them. So it is a grandparents' place and now she is residing there. Because after marriage, she did not go to the parents' house. She went to the grandparents' house because it is a lady, after marriage, why you are still here will be the question, and she wanted to avoid that. And she started living with the grandparents. As it now stands, please notes, she is not even working. That's what has been. That week's time is given, I will file the documents to show that she is not working.
Land counsel by the husband shall file an affidavit before this court. A wife shall file an affidavit before this court. No, the wife shall file an affidavit before this court stating that the wife is not working and she is completely residing in Nanjangud.
Please.
From what time she is residing there?
Please, madam.
Kindly may I permit
2004
read only
it has
one, three sentences in the petition, one petition.
Hmm.
Para 19, page 19, para 7 of the petition.
Which she said?
May I read, my lord?
Stay is there in this? Stay is
Stay is there,
granted.
please.
Stay is there.
Stay granted earlier is extended to the next date of hearing. Give a date. Yes, next.
20th, 20th. 13.
I appear for sought for transfer of petition.
Same old story.
Same old story, Your Lordship.
From where to where?
From Vascote to Madhur, Your Lordship. Child is settled there, Your Lordship. School is
Kote to Madhur.
Madhur, Your Lordship. My lord decision is also there, Your Lordship.
No, according to them, you are working in Mysore, if I remember.
No,
You're
no.
working in Bangalore. or
Bangalore,
Mysore.
that's what they say, my lord. No doubt I am working, my lord, but I have to look after my child, my lord, immediately after the class work is over. I have to go back to the Madhur, travel to Madhur, my lord. I have to look after the my lord, child, your lordship.
That can't be a reason.
That is the reason, my lordship.
You are
But there are
working in
three-
Bangalore.
There are three cases.
First of all, you are working in Bangalore or Mysore, whatever it is.
Yes.
And you will keep your child at Madhur along with
No,
the grandparents. And
Madhur,
you
no,
will
no,
file a case
no, my
there.
lord. Child is with me only, my lord. Now the child is with me only.
Be with you where?
With the Madhur only, my lord. I have a
Working where?
working in Bangalore, my lord. Every day she,
You're coming to
every day
Bangalore.
she travels, my lord, from Madhur to Bangalore, my lord.
No, you are coming to Bangalore. There is no difficulty for you to attend the course at Bangalore.
My lord.
You're coming to Bangalore.
Yes.
There is no difficulty for you to attend the
In
course.
between here, my lord, Chanpatna, Ramnagar, my lord, it will be helpful, your lordship. Otherwise, it will be very difficult, your lordship.
Already
80
is made to travel every day to see the child from here to Madhur.
No, they are coming, my lord. There is no problem at all, my lord. In that regard,
The
your
case
lordship.
is already
The-
posted for
the-
cross-examination of
The
PW1.
domestic violence.
Already
my lord,
one more
which was
petition
filed
filed before the
there.
court. This
There
honorable
are
court
three
already
cases, my lord,
passed an
which are
order,
filed.
page number 20. Earlier order, he filed a challenge
There are
before
two
the court.
cases, my lord, which are before
This
the.
honorable court
pending
already
before-
are passing the order, my lord. The learned petitioner suppressing the real fact, unnecessary drag on the proceeding. They also filed IA order 7 rule 11 1 and 2. This case, the application pending before the court today posted for hearing and even till today not appear before the court petitioner on this case. Simply 5 cases
Now-
pending.
Now this particular MC is posted for?
GNWC.
Posted,
GNW posted for today for further cheap evidence of
With
PW1.
regard to jurisdictional point, my lord, the
In
case
this
is going
stage,
on, your
in this stage,
Argument is there.
in this stage, the petitioner filed a application under order 7 rule 11 A and D, page number
Correct.
160
NWC is of picture.
and 23, my lord. 23, my lord.
Jurisdictional point,
The
my lord, territorial
objection-
jurisdiction, my lord, it is to be decided, your lordship. I have considered this issue, my lord, before this court also.
Page number 162, in
Over,
my
my lord,
objection, my
was,
lord, the petitioner himself is filed application under order 7 rule 11,
Please come.
page number 162 in objection.
The present petition is filed seeking to transfer GNWC number 37 or 20.
Not the GMWC, my lord, the. Yes,
GNWC.
criminal miscellaneous 449, your lordship.
No. In this case, filed by the petitioner
Look at the
seeking for
prayer,
GNWC.
prayer at page number 10.
Prayer, my lord. 475 is the case, my lord.
Yes,
Yes, 470,
prayer.
CP 475. Transfer criminal miscellaneous petition number 449 of 2000.
Why, for you, the papers, what your, it is for.
No, my lord.
I will check.
FR is 476, sir.
I will check up, my lord.
No, my lord.
Because, my lord,
My
475
lord
number is.
was suppressing the real fact of 2 cases
Sorry,
there. 2
don't
cases
tell all
there.
those things again and again.
My lord.
There is the question of
CP
suppressing the fact.
CP number 475 bar 2024.
See, with all of you, yes, you can make your submissions.
Yes.
Why should you say that other counsel?
All times whenever the matter comes, my lord, this is the submission made by him.
No, give him this.
Yes, my lord, I will find out and I will make.
No,
I will
adjournment
check.
is required for that. Give it to him.
Yes, I will check up. There are.
Call
three
the
pe-
next case.
There are
Hear
three
it,
petitions.
look at it.
Yes, my lord, there are 3 petitions filed, your lordship, that's the reason.
See,
That
is
must
the
be the
petition is
ca-
from the MC.
Yes, my lord.
Yes, and we'll list other 2 matters also
Yes,
and pass order.
yes.
What are the other 2 numbers?
Other 2 numbers, my lord,
476,
476,
Paper and give all the 3 petitions.
Yes.
This is my matter, all these 3 petitions tomorrow.
1335,
Yes, it will
2025.
come, it will come, give the list.
Yes, Lord.
Yes, next.
14. The judge for petitioner.
My lord,
And
the wife's
property.
petition seeking transfer of the proceedings from my lord Shivamogga to Mysore.
Shimoga,
To Mysore, my lords, the distance is about 250 kilometers,
how much?
250 kilometers, my lords.
Shimoga to?
Mysore.
Hmm.
Lords, the wife is a resident of Mysore, my lords. The petition preferred by the husband in Shivamogga court for restitution of conjugal rights.
Hmm.
Lords, in his petition himself, he acknowledges that the wife, who is the petitioner before this court, is physically handicapped. And they have 2 children, my lords. Have produced the disability certificate.
Children or with the mother, with the,
Please, my
with the
lords, they are
wife.
with the mother.
The MC is for restitution.
Restitution, please, my lords.
And what about notice?
Lord, it is
Served, not
served,
appearing.
Not appear, please, my lords.
The present petition is filed. Seeking transfer of MC number 289 of 2024. Pending on the file of the Family Court Shimoga to the Principal Judge, Family Court Mysore. It is, the facts of the case are that the marriage has taken place on 29/12/2012 at Mysore. And out of the and in the wedlock, they're blessed with 2 children who are aged 11 years and 8 years. And they're studying at Mysore and staying along with the petitioner mother. In view of the differences between the parties, the husband had filed MC number 289 of 2024 before the Principal Judge Family Court Shimoga seeking restitution of conjugal rights. And the notice was issued to the petitioner on 11/9/2014. It is stated that the distance between both the places is 250 kilometers, and apart from that, she's having 75% locomotor disability, and further had to take care of the children. No notice is served in the respondent. No wakalat is filed on behalf of the respondent. Considering the arguments of the learned counsel for the petitioner wife and the fact that the distance between Shimoga and Mysore is 250 kilometers and all, and the wife is suffering, the wife is physically handicapped, suffering with 75% disability and has children to take care. This court deems it appropriate to pass a following order. So-and-so pending on the file of so-and-so is withdrawn and transferred to so-and-so accordingly allowed.
Number 15. Nataraju T.
Wife's petition are taking transfer from my lord Kadur to Chitradurga, my lord.
Where?
Kadur to Chitradurga, 100 kilometers, my lord.
Distance.
100 kilometers for one way, my lord.
Counsel for the petition is present, no representation for the respondent. List this matter as part heard.
Please.
Yes, next.
Interim order, my lord.
Interim order early
Please.
granted is extended to the next date of hearing.
Please.
17.
Yes, next.
16. Rangaramu D.
His wife petition, my lord. The husband has filed a case at Chandrayapatana. Though he is working at Mysore, the address shown in the cost title may be permitted.
What is the distance between both the places?
140, my lord.
140. But which year is the MC?
This 2024, my lord. Next year.
Learned counsel for the petitioner submits that though husband is a resident of Mysore, he have filed the case at Chandrayapatna. Wife is residing at Mysore, and the distance between both the places is 140 kilometers. It's very difficult for the wife to travel on each date of hearing. Any children?
One son is, child is there, 3 years.
And she has to take care of the son who is aged about
3 years.
3 years. Considering the reasons stated, there shall be stay of all further proceedings in so-and-so, so-and-so, till the next date of hearing. The petitioner shall serve shall take out hand summons on the counsel appearing with the respondent before the trial court and file a memo to that effect by 3rd of April. Or else the stay granted by this court stands vacated without further reference to the court. Next.
Number 3.
And in addition, registry is also directed to issue notice. Mega, in all cases, in addition, registry. Yes, next.
Serial number. List number 3, serial number 1. PB Raju for appellant.
230.
Serial number 2 for urgent. Serial number 3. R. J. Prakash.
Appellant.
You are for the appellant. Who appears for the respondent?
That is
PB Manjunath.
PB Manjunath. PB Manjunath.
You want a passover or tomorrow?
Call it,
Huh?
call it next day.
What he says?
Next.
Next week. Huh?
Next week.
No representation for the respondent. Counsel for the appellant is present. This is matter, give a date next week. Yes, next.
Serial number 4. Karunakar P. For appellant, Justice Rajashekar for R2.
No representation. List this matter for dismissal. Give a date.
14/3.
Yes.
Serial number 5. Renuka HR. K.L. Srinivas.
For the respondent.
Yes.
I appear for the respondent.
Lord, sir. This is an appeal arising out of the case for.
My case.
Yes,
She's
yes.
for the appellant
Yes.
here, she's for the appellant. she
Alala,
has to argue.
I am bringing to the notice of the Sanval Court that the statutory deposit has not been made in this appeal. So the appeal without the deposit itself is not maintainable. My lord, the order sheet dated 14/12/22 may be kindly looked into.
My lord, it's not so. The appeal itself will not be entertained, my lord. I do not know what he is,
Verify from the record, pass over. Yes, next.
Cell number 6. Mahesh BJ.
Hmm. Is it on enhancement or liability?
Appeal filed by the owner of the vehicle challenging the liability fixed against him.
What is
As on the date of accident, the driver who has not renewed the driving license, the driving license has not been renewed. The date of accident is 16/5/2011. The DL expired on 17/1/2016.
17/1?
2011. 17/1/2011.
Hmm.
DL renewed on 19/5/2011 to 18/5/2014, subsequent to the date of accident.
No representation for the appellant for dismissal. Counsel for the
14/3.
respondent is present.
Cell
Yes,
number
ma'am.
7 adjourned. Cell number 8, Abhinav YT for appellant.
This case also dismissed.
Narasimhachar.
Time petition has been dismissed.
Same in this also, no representation. Counsel for the respondent is present for dismissal.
17/3. Cell number 9. Cell number 9.
No,
Srinivas
no
KS.
representation on behalf of both the parties. Same for dismissal.
17/3.
Yes.
Cell number 8, 10. Cell number 10 adjourned. Cell number 11. Jagdish HT for appellant. Number 11.
Dismissal.
17/3.
No representation on behalf of either of the parties.
17/3. Cell number 12 adjourned. Cell number 13. Sripad V Shastri for appellant. BJ Mahesh for respondent.
Same order. Don't give all the matters on the same day. Give different dates.
18/3.
Yes.
Cell number 14, 15 adjourned. Cell number 16. Harish Babu KN. Please submit.
Huh? No representation for the appellant. He's seeking adjournment. For what? Give a date. 17.
21. Cell number 16, 21, 3. Cell number 17, Chetan Nagesh. 17,
Same. No representation for dismissal.
18, 3. Cell number 18 adjourned. Cell number 19 adjourned. Cell number 20, Kalimullah Sharif.
No, why don't the insurance company councils give the list of matters? And every matter is being adjourned. Even no satisfaction of working at all.
Please.
Any of you who are ready, give the list, whether they are there or not, will decide, all of you.
20, Kalimullah Sharif. VB Sidramaya for respondent.
For dismissal.
19/3. Cell number 21, AL Srinivas,
The appellant, my lord, sir.
KK Vasant.
I appear for the respondent.
My lord, sir. I may be
Not
permitted.
filing of the synopsis for the council by the appellant council as per order dated
Please.
6/1/20.
Just now I saw the copy. I may be permitted to file it.
You take that. Please come to the appellate court's order.
My lord, the judgment of the appellate court is at page number 44, my lords. My lords, the appeal by the defendant, the suit for declaration and consequent relief of injunction.
Where is the reasoning part?
Please, my
Come
lords.
to the reasoning part and it starts at page 23.
The typed copy of the judgment is produced from page number 44,
I'm looking at the appellate court's order.
appellate court's order.
At
Because,
page number 24, I'm reading.
please,
Internal page 15 of the appellate court's judgment.
para number 16 also. On perusal of the plaint governments, it is noted that at para number 9 of the plaintiff has clearly taken a specific plea that the defendant with a malafide intention has illegally and unlawfully excavated land belonging to her to a depth of about 3 to 4 feet by using machineries on 15/2/2016, which portion of land has been shown as the B schedule property in the plaint and forms part and parcel of suit A schedule property. Further, the plaintiff has stated that the defendant, with an intention to put up a poly house or green farmhouse in his land, has leveled a portion of land described as B schedule property and has removed the fertile soil. The plaintiff has further stated that the rough sketch appended to the plaint shows the encroachment made by the plaintiff in the B schedule property. Such being the case, it is pertinent to note that in view of the alleged encroachment, the plaintiff has not sought for the relief of position of mandatory injunction for directing the defendant to quit and hand over vacant position of the encroachment or removing the encroachment and handing over possession of the B schedule property to her. The Honorable Supreme Court in the case of so-and-so has held that where the title of the plaintiff is not visible, but he
What appears is,
is
counsel with the respondent. What appears is, you have sought for the relief and by seeking an amendment of the plaintiff that has been rejected.
So one prayer is allowed and
Rejected, other prayer is allowed. So as far as the rejected prayer is concerned, the plaintiff
Declaration.
has not carried it in appeal.
yes, yes.
When it has not carried in appeal and that remains unchallenged, and what is the business of the appellate court to say that it should have been that way, otherwise it should have
I
been that
make
way?
some. Not so far a declaration is concerned, there is no dispute whatsoever with regard to the title so far a plaintiff title in respect
No,
of.
initially-
I submit.
No, let me understand the facts. Initially, you have filed a suit seeking a permanent injunction
Yes,
and also damages,
yes,
isn't it?
yes.
Then what is the relief, what is the amendment that you sought?
You sought for declaration of title over the Schedule A property
Mm.
and actual recovery of possessions over Schedule B property is concerned.
Yes.
So now what has happened, my lord?
Initially, your case is that you are in possession of the property.
Yes,
And now which prayer is allowed, which prayer is dismissed?
So far as amendment of the schedule is concerned, that is number of the property is considered allowed. But so what declaratory relief is concerned is rejected. But that has not been actually called in question by.
So in
by
that
appeal.
case, how can the appellate court go into that amendment, that order that is passed by the trial
That is
court?
wrong. One way it is wrong. They
That's
could not
the-
have gone into that. Even apart from that,
Hmm.
what has happened in that, only the disputed area is B schedule property, that is 2 guntas of land, some 2 guntas of land. There, the seeking possession is also superfluous for simple reason that he excavated the soil. Excavated soil and removed all the fertile soil from that place that belongs to the plaintiff.
But again, that go back to the same fact. Now, unless and until you have the recovery of possession, you have to have the.
No, it's not the case that he is squatting on that property. Only he excavated the soil from that B schedule property. That is a part of Schedule A property. The fertile soil he has removed for the purpose and utilized it. But so far that area is concerned, that area is leveled so as to enable him to actually put up some greenhouse and something in this property. So he is not in possession of that property at all.
Then why
Excavated.
ask for the recovery of possession?
No, not necessarily recovery of possession.
You
Not-
asked. You
That is
asked for recovery.
that's
of
what he
possession.
said, superfluous, mandatory injunction.
Mm.
Without only the case,
And you asked for recovery of possession, that is rejected.
no, that is not rejected. Recovery of possession, not rejected. Declaration is rejected. That's what the synopsis my learned friend has given. That is,
Well, that's why please come to para number 19. Let's read para number 19. You read. Para number 19 of the appellate court's order. At page
Yes.
number 27.
yes. Such being the case, learned trial court has erroneously and without proper application of the settled principles of law, reject IA number 12, filed by the party seeking to include the relief of possession by way of amendment, which was necessary for the purpose of determining real question in controversy. Not that I don't have that application. What is nature application file?
My lords, I have got the copy of the application
Give
already.
it to him, give it to him.
Yes, that is the prayer. Reject again.
This, the whole finding and remanding the matter itself is bad. The appellate court has no business to go into all the facts which have attained finality.
My lord, the matter may be remanded to first appellate court for the purpose of redetermination of the issues. So
It
for
has to be decided.
RA,
We'll set aside this order on the merits of it, let the first appellate court decide it.
yes, ma'am. That may be.
Yes, please come. The present MSA, present appeal is filed, agreed by the judgment and decree passed by the appellate court in RA number 14 of 2021, dated 28th March 2023, whereby the court had set aside the judgment and decree that is passed by the trial court in OS number 86 of 2016, dated 20th January 2021, and remanded the matter for fresh consideration. The brief facts of the case are that the plaintiff had filed the suit for the relief of declaration. The plaintiff is the absolute owner of the suit Schedule A property and perpetual injunction to direct the defendants to pay damages of rupees 75,000 together with interest at 5% per annum and for other reliefs. It is the case of the plaintiff that the suit Schedule A property was purchased by her grandfather in the year 1972. Since then, he was in possession and enjoyment of the property. After his death, plaintiff's father was in possession property. The defendant had purchased 45 guntas on southern side of the same survey number from the same owner during 1985. In the said survey number, there was about 4 guntas Karab land reserved for road. But the defendant, in collusion with the revenue officials, got mutated the said 4 guntas of Karab land in his name, including the same, in the 45 guntas purchased by him, and created revenue documents of 50 guntas. It is the case that the encroached portion is shown as the B schedule. In the said encroached portion, the defendant has dug and removed the fertile soil to construct poly house or the greenhouse, thereby cause damage to the plaintiff, and accordingly has come up with the suit. The defendant has filed his written statement and denied the case of the plaintiff.
No, he admitted that the plaintiff is the owner of the issued property.
He admitted as far as ownership of the plaintiff with regard to A schedule. But as far as B schedule is concerned, he has denied the same. In the suit, during the pendency of the suit, the plaintiff had filed an IA seeking amendment, seeking the relief of recovery possession, and also to amend the
survey number.
Survey number. Amend the survey number.
Survey number as 41A.
That is serial number 7 in the chronic book.
he has filed IA number 12,
2 ಅಂತ ಬರ್ತದೆ 12 ಆಗ್ಬೇಕು. 2 ಅಂತ ಬರ್ತದೆ.
seeking to amend the prayer
IA
by
number 12
deleting the
ಆಗ್ಬೇಕು.
prayer B, and in its place to add consequent upon such declaration to grant the decree of possession directing the defendant to hand over the vacant possession of the B schedule property to the plaintiff, and also to amend survey number 40/1A in A schedule as survey number 40/1A2. And the defendant had filed his objections. The court had party allowed I number 2, permitting.
IA number 12, your lordship.
A number 12, permitting to amend the survey number 40/1A in A schedule as survey number 40/1A2, but rejected the prayer to delete prayer portion and to add the relief of decree of possession. The plaintiff had not questioned the said said order passed by the court in I number 12. Thereafter, the trial court, after a full-fledged trial, had come to the conclusion that it can be held that the plaintiff has proved the encroachment by the defendant for the suit schedule property of the plaintiff. Then when it comes to the damages, plaintiff is entitled for the damages worth rupees 75,000 and also for the relief of permanent injunction against the defendant. And accordingly, the court had passed a judgment and decree by decreeing the suit. Aggrieved thereby, the defendant has preferred RA number 14/2021. The appellate court had remanded the matter. The reasons for remanding the matter by the appellate court is that the trial court had wrongly rejected I number 12 filed by the plaintiff, seeking to include the relief of possession by way of amendment, which was necessary for the purpose of determining the real question in controversy between the parties. So the the suit of the plaintiff without seeking the relief of position is not maintainable. It is not proper to dismiss the suit as an application for amendment to include such a relief has been erroneously rejected by the learned judge. It is also observed that without permitting such an amendment, the trial court ought not to have proceeded to pass the judgment and decree. Therefore, the circumstances, in these circumstances, and the principles of justice mandate that the plaintiff should be given an opportunity to include the relief of position, which can be done only by remanding the matter for retrial. As such, inclusion of the relief of possession would entail framing of appropriate issues and adducing of additional evidence, and accordingly remanded the matter by setting aside the judgment and decree passed by the trial court. Aggrieved thereby, the defendant is before this court by filing the present miscellaneous appeal. Now, in counsel appearing for the appellant submits that when the finding with regard to I number 12 has attained finality and the same was not questioned by the plaintiff, the observation of the court that the trial court ought to have allowed the application and ought to have allowed the amendment is contrary to law and beyond the scope of appeal. All these things, the court had gone beyond the jurisdiction conferred on the appellate court and remanded the matter. It is submitted that the reason for remand is not a well-considered one and the order needs to be set aside. Next paragraph. Learned counsel appearing for the respondent plaintiff submits that the court had rightly remanded the matter, looking at the substantial interest of the parties and with the substantial justice, and no prejudice would be caused to the appellant if the appeal is remanded and an order is passed on the merits of it. He submits that no interference is called for in this appeal. Next paragraph. Having heard the counsels on either side, produce the material on record. Initially, the suit was for declaration and for damages. According to him, he is the owner of the A schedule property, and B schedule is the one which is encroached by the defendant. Then I number 12 is filed, seeking to amend the prayer, that is seeking a recovery of possession and also to amend the survey number. Court has allowed it partly by permitting him to amend the survey number, but when it comes to the recovery of possession, that was dismissed by the court. For the best reasons known to the plaintiff has not questioned the said order, and the order passed by the court in I number 12 has attained finality. Thereafter, the trial court has passed a judgment and decree whereby the suit is decreed as prayed for by the plaintiff. And when the defendant has carried the matter in appeal, the appellate court ought to have looked at the legality or otherwise of the judgment and decree. Instead of that, court has gone to the aspect of whether the said IA that is filed by the order that is filed in IA number 12 is legal or not. And court has come to the conclusion that unless and until the IA is allowed, the injustice would be caused to the plaintiff, and at that stage, demands a matter. In the considered opinion of the court, the such exercise done by the court is contrary to law. When the plaintiff had an opportunity to question the order that's passed in I number 12, when he has not chosen to question the same, the court ought not to have gone into the aspect, and the court ought to have looked at the merits of the judgment and decree and ought to have passed an order. This aspect of remanding the matter on this ground, permitting the petitioner, appellant, permitting the defendant to, the plaintiff to amend the, granting him the relief of amendment that is sought by him in an appeal is exceeding the powers conferred on the court. In that view of the matter, this court deems it appropriate to set aside the order passed by the court in RA number 14 of 2021, dated 28th March 2023. And the matter is, and the remand order is set aside and the order of the trial court is restored and the appellate court shall decide the appeal on the merits of it. Done? Accordingly disposed of. Any of the matters were ready in the past over matter?
My lord, this may be open to the plaintiff
Ah.
to take up any cross objections in the matter. That may
This,
be.
whatever is the remedy available to the parties with regard to the cross objections and other things.
Before the appellate court.
Before the appellate court, they are at liberty.
Lords, in the chronological events, just now, I may be permitted to correct the IA number as 12 instead of.
Who is ready? Which one? Huh.
So probably my lord, it is lost the sight and I don't usually in 2016, my narrative has appeared before the court. And the points out my lord only after 4 years.
Deposited. Land counsel, the appellant is permitted to deposit the amount. It is submitted that in fact, an application is filed to deposit the said amount before this court and the same is pending consideration. What is that IA?
Permission to deposit.
IA number. 3 of 20? 3 of 2013 is filed to deposit the amount before this court and the same is pending consideration. Look at that, whatever is IA number so and so is permitted, the appellant is permitted to deposit the amount before this court within a period of 1 week, list after the amount is deposited. That's it. Give them a date, tell the advocates and give the date for it.
Notification jurisdiction ಬಗ್ಗೆ ಮಾಡ್ತಾರೆ jurisdiction
ಸರ್ 9 ಯಾವ ಟೆಸ್ಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ರು ನಾಗರಾಜ್ ಸರ್ ಸರ್ ಓ ಮಹೇಶ್ ಸರ್ ನಿಮ್ ಫ್ರೆಂಡ್ ನಾಗರಾಜ್ ಅವ್ರಿಗೆ ಆನ್ಲೈನ್ ಬರಕ್ ಹೇಳಿ ಸರ್.
ಆಯ್ತು ಹೇಳ್ತೀನಿ ಮೇಡಮ್. ನಮ್ದೇನಾಯ್ತು?
ಯಾವ್ದು ಸರ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 7, 14 ಟೈಮ್ ಕೇಳ್ತೀನಿ ಅಂದಿದ್ರು.
ಯಾವ್ದು ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್?
ಲಿಸ್ಟ್ ನಂಬರ್ 3, ಸೀರಿಯಲ್ ನಂಬರ್ 7, 14.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 7
ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತೀನಿ ಅಂದಿದ್ರು.
7 ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್, ಅಪಲೆಂಟ್ ಅಡ್ವೊಕೇಟ್ 2 weeks.
14 ಮೇಡಮ್.
14 ಒಂದ್ ನಿಮಿಷ 14 ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್. ಪ್ರಕಾಶ್ ಎಂ ಪಾಟೀಲ್ ಸಾಹೇಬ್ರು ನಾಟ್ ವೆಲ್ ಅಂತ.
ಆಯ್ತು 17 ಮೇಡಮ್.
17 ಸರ್ ಒಂದ್ ನಿಮಿಷ ಇದೆ ಡೇಟ್. 17 ಒಂದ್ ನಿಮಿಷ ಅದು 18/3 ಡಿಸ್ಮಿಸಲ್ ಹೋಗೈತೆ, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅದು ಅಪೆಲೆಂಟ್ ಗೆ.
ನೋಡಿ ನಾಗರಾಜ್ ಬಂದಿದ್ದಾರೆ ನೋಡಿ.
ನಾಗರಾಜ್ ಸರ್,
ಹೇಳಮ್ಮ.
ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಅಲ್ಲಿ ಯಾವ ಡೇಟ್ ಬೇಕು ಸರ್? ಅವರು ನಿಮ್ಗೆ ಯಾವ ಡೇಟ್ ಸರ್? ರೆಸ್ಪಾಂಡೆಂಟ್
ನಮ್ದೇನಿಲ್ಲ ಮೇಡಮ್, ಅವ್ರಿಗೆ ಯಾವ್ದು ಬೇಕು
ಯಾವ್ದು ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ ಅದನ್ನ ಕೊಟ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ರು ಮೇಡಮ್.
ಮೇಡಮ್ ಯಾವ್ದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ ಮೇಡಮ್, ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಫುಲ್ ಆಗ್ಬಿಟ್ಟಿದೆಯಲ್ಲ ಸರ್, ರೀಚ್ ಆಗಲ್ಲ. ಇದು ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಆಗ್ಬೇಕಲ್ಲ ನಿಮ್ಗೆ.
ಅದಕ್ಕೋಸ್ಕರನೇ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ರೆಡಿ ಇದ್ದೀರಾ ಸರ್?
ಅವ್ರದ್ದೇ ಮೇನ್, ನಮ್ದೇನಿಲ್ಲ.
ನಾವ್ ರೆಡಿ ಇವತ್ತಿಗೆ ರೆಡಿ ಇದ್ದೀವಿ.
ಯಾರೋ ಗಣಪತಿ
ಅವ್ರು ಗಣಪತಿ, ನಮ್ದೇನು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ನಮ್ದೇ.
ಗಣಪತಿ ಅವ್ರಿಲ್ಲ, ಅದಕ್ಕೆ
ಕೊಡಿ ಮೇಡಮ್, ಕೊಡಿ.
ಒಂದ್ ನಿಮಿಷ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್ ತೆಗಿತೀನಿ ಸರ್. 27ಕ್ಕೆ ಹಾಕ್ಲ ಸರ್?
ಆಯ್ತಮ್ಮ,
ಹಾಕಿ ಮೇಡಮ್.
27
ಮೇಡಮ್ ಸಾಹೇಬ್ರೆ, ಮೇಡಮ್ ಅವ್ರು ಹೇಳಿದ್ರ ಟೈಮ್ ಕೊಡೋಕೆ?
ಸರ್ ಅದು ಡೇಟು ಕೊಟ್ಬಿಡಿ ಕನ್ವೀನಿಯಂಟ್ ಅಂತ ಹೇಳಿರ ಬಿಕಾಸ್ ಈ ಸೀಕ್ಸ್ ಅರ್ಜೆಂಟ್ಮೆಂಟ್ ಇನ್ ದ ಮಾರ್ನಿಂಗ್ ನೋ ಸರ್. ಅಪೆಲೆಂಟ್ ಇನ್ ಸಮ್ ಆಫ್ ದಿ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಈ ಸೀಕ್ಸ್ ಟೈಮ್
ಆಯ್ತಮ್ಮ. ಓಕೆ,
ಅದಕ್ಕೋಸ್ಕರ
ಸರಿ ಅಮ್ಮ.
27 ಸರ್.
ಆಯ್ತಮ್ಮ.
ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪೆಲೆಂಟ್ ಅಪೆಲೆಂಟ್ ಇನ್ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್.
Okay, madam. Thank you.
ಇನ್ನೊಂದು ಪಾಸ್ವರ್ಡ್ ಒಂದೇ ಒಂದು ಬಿ ರಾಜು ಸರ್ ಮೇಡಮ್ ತಗೊಂಡಿದ್ದು ಅದೇನಾ ಇವಾಗ?
ಅಲ್ಲ, ಅದು 5. ಅದಾಯ್ತು.
ಎನ್ ಕುಮಾರ್ ಫಾರ್ R1 ಇದೆ.
ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ
1
ಸೀರಿಯಲ್ ನಂಬರ್
1 5 ಆಯ್ತು. 5 ಅಲ್ಲಿ ಸಬ್ಮಿಟ್ ಡೆಪಾಸಿಟ್ ಆಯ್ತು. 1
ಲಿಸ್ಟ್ 3 ಅಲ್ಲಿ 1.
ಲಿಸ್ಟ್ 3 ನಲ್ಲಿ 1 ಅಪ್ಪ. ಯಾರು
ಲಿಸ್ಟ್ 3 ನಲ್ಲಿ